This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, we'd like to talk about fortuity and how the doctrine of fortuity is both an affirmative defense that can defeat almost any claim and why a magistrate judge has determined that defense can be waived. Homeland Insurance Company of New York sued Clinical Pathology Laboratories, CPL, and CPL's parent company, Sonic USA, collectively the defendants, for a declaration that it has no duty to reimburse the defendants for defending a number of medical negligence lawsuits filed against them in Ireland. In a case called Homeland Insurance versus Clinical Pathology Laboratories et al., a July 19, 2022 decision of the U.S. District Court, Western District of Texas, Austin Division's Magistrate Judge, in his recommendations to the District Court. CPL is an Austin, Texas-based provider of medical laboratory services. CPL and Sonic USA are subsidiaries of Sonic Healthcare Limited, a global healthcare company headquartered in Sydney, Australia. Sonic also owns Sonic Healthcare Ireland Limited and MedLab Pathology, both of which are Irish providers of medical laboratory services. On June 30, 2013, Homeland issued a medical facilities and providers professional liability, general liability, and employee benefit liability policy to Sonic USA and CPL for the policy period June 30, 2013 through June 30, 2014. The 2014 policy covered certain claims for wrongful acts and personal injury. The parties renewed the 2014 policy for the 2015-2016 period. Notably, the 2014 and 2015 policies covered only claims made in the United States, its territories, or Canada. In August of 2015, the family of a woman, Mrs. O.I., who died after developing cervical cancer, filed a negligence lawsuit in Ireland against CPL, Sonic USA, and other entities based on alleged misread pap smear slides. After CPL was served with the lawsuit, it filed an insurance claim with Homeland, only to find that Homeland denied the claim because the 2014 policy did not cover lawsuits filed in Ireland. Once defendants became aware of their gap in coverage, they sought to secure worldwide coverage from Homeland starting with the 2016-17 policy period, so that if similar claims arose in the future, they would be covered. Homeland agreed to provide such coverage, and on August 30, 2016, the parties executed a worldwide territory endorsement to the policy, which extended coverage to claims filed against the defendants outside the United States of America, effective on June 30, 2016. Homeland alleged that it agreed to the expanded coverage only after requiring defendants to agree to certain warranties in a letter dated July 27, 2016, written by Stephen Schumpert, then CPL's president and director, and Sonic USA's chief executive director and director, who promised there were no pending claims. Homeland issued the same WTE endorsement to defendants' 2017 policy, which is effective June 30, 2017 to 2018. In August of 2018, the family of Ms. S. filed a negligence lawsuit in Ireland against MedLab based on an alleged misread pap smear slide. Sonic Ireland and CPL were added as defendants in May of 2019. CPL settled the case in October of 2019. MedLab and Sonic Ireland did not contribute to the settlement. On July 10, 2020, Homeland denied CPL's claim on the grounds that 1. The 2016 and 2017 policies' prior knowledge and prior notice exclusions precluded coverage because MedLab had provided notice of the Ms. S. claim to MedLab's insurer, Vero Insurance Company, in 2016, and 2. The 2016 letter was inaccurate and contained misrepresentations. Eventually, in July of 2020, Homeland sued CPL, Sonic USA, Sonic Ireland, Sonic Limited, and MedLab, seeking a declaratory judgment that there is no coverage for the Ms. S. claim under the primary policy or the excess policy based on the prior knowledge and prior notice exclusions and because the 2016 letter was inaccurate. Because the purpose of insurance is to protect insureds against unknown or fortuitous risks, fortuity is an inherent requirement of all insurance policies. The fortuity doctrine relieves insurers from covering certain behaviors that the insured undertook prior to purchasing the policy. Under the doctrine, an insured cannot obtain coverage for something that has already begun and which is known or should have been known to have begun. The fortuity doctrine precludes coverage for known losses or losses in progress. A known loss is one that the insured knew had occurred before the insured entered into the contract for insurance. A loss in progress is an ongoing progressive loss that the insured is or should be aware of at the time the policy is purchased. The fortuity doctrine does not require an insured to have specific actual knowledge of the loss. Instead, the doctrine precludes coverage when the insured is or should be aware of an ongoing progressive or known loss at the time the policy is purchased. In addition, it has been recognized that the known loss doctrine does not apply if the insurer also knew of the circumstances on which it bases the defense. The insurer, of course, bears the burden of establishing the fortuity doctrine bars coverage. In recent years, the fortuity doctrine's no loss and loss in progress rules have become potent affirmative defenses in coverage litigation that carriers have turned to with increasing frequency. The doctrine has its roots in the prevention of fraud, because insurance policies are designed to insure against fortuities. Fraud occurs when a policy is misused to insure a certainty. Fraud is an affirmative defense under Texas law, and for these reasons, the court concluded that the fortuity doctrine is an affirmative defense under Texas law. However, based on the specific facts of the case, the court found that Homeland's delay in raising the fortuity defense constituted an unfair surprise on the defendants. Homeland did not request and was not granted leave to assert the fortuity doctrine defense when it filed an amended answer. The magistrate judge therefore concluded that Homeland nevertheless waived its fortuity defense because it did not assert the fortuity doctrine until its response to defendants' motion for summary judgment. The fortuity issue is one of many issues brought into the court and resolved by the recommendations of the magistrate judge. The district judge has the right to accept or reject the recommendations of the magistrate judge's lengthy opinion. Since there is a need for fortuity as the essence of insurance, and as a recognized unwritten exclusion in every policy, it appears the magistrate judge, in my opinion, erred when he concluded that asserting the defense late is an unfair surprise on the defendant insureds, since the insureds should have known that fortuity is always an unwritten exclusion and could not therefore be surprised, fairly or unfairly. And I would assume that one of the affirmative defenses, which is always asserted in every lawsuit I have ever seen, that the insureds failed to assert a cause of action, should be sufficient to assert the fortuity defense, because one cannot assert a cause of action unless the insured can prove that the loss was fortuitous. This video was adapted from the blog post, Zalma on Insurance, which is available at www.zalma.com/blog, and which is also provided to my locals community and to substack.com, to which you should subscribe. Thank you for your attention.